here's what's happening. The Wayfair company is running an investigation alongside this litigation. And the question is, what is the purpose of that investigation? Does that investigation mess up or interfere with the litigation? And are the records of that investigation available to the other parties in the litigation? That's essentially the dispute. So the investigation firm that was brought in to do this investigation said in one of its letters that the scope of their investigation was whether Lively filed complaints and whether Wayfair failed to investigate them. So they are not investigating, was there sexual harassment necessarily, or was there retaliation? They are investigating this issue, this sort of side issue of, did she make complaints where the company should have investigated at the time? And do they have potential liability for failing to investigate at the time? That can be a piece of the sexual harassment or retaliation, but it's sort of a subsection of what's happening in the litigation. Now, the Lively people hate this. They are strongly against it. They have said this from the very beginning. They want no part of it. And frankly, they think it ought to stop because these investigators reached out to Lively and were like, hey, would you come in and talk to us? And she's like, fuck you, no. And then they've been sending lawyer letters back and forth about sort of the propriety of the investigation. This is really tricky because Wayfair didn't start the investigation, the sort of internal Wayfair investigation, until the lawsuit was filed. And they're claiming we weren't aware of it before that. We saw these allegations that we missed complaints and we missed an investigation, so we decided to go ahead and do it now. But at the same time, the Lively people are right that it does allow them to do a little bit of a shadow investigation alongside this litigation and say that it's covered by attorney-client privilege. So I will say, as someone who has participated in literally hundreds, if not thousands, of internal investigations like this in employers, all the laws say you have to have a neutral decision maker, a neutral investigator. And I'm here to tell you that you will never find somebody that everybody thinks is neutral, because nobody's going to do it for free. So if it's a person inside the organization, then everyone says, yeah, well, they report up to the leader and the lead, right? So they're still under the thumb of the organization. If you bring somebody in from the outside, that person expects to be paid. And so the company's going to pay them. And they say, how can you possibly be neutral and independent if you're being paid? So it's one of those legal requirements that's practically impossible to meet. The only thing you can really do is what it seems Wayfair has tried to do here, which is to hire a totally separate firm that is not representing Wayfair in any case, and not in this case, to do a separate investigation that is not directed by Wayfair. So this investigation firm says in its letters, and I'm going to assume because they're lawyers that they're telling the truth, they have not been hired to advise anybody on the law. They are not hired as litigation counsel. They are hired as investigative counsel, and that Wayfair said, here's the scope of the stuff we want you to do, and that Wayfair doesn't sit there and tell them, talk to this person, write this in the report. That's what they say. And I can tell you that it is very common for lawyers to be the ones who come in and do internal investigations like this, because they're the only people who really fully understand EEO law to a degree that they can do this kind of investigation. So there's a baseline fight between the parties about, like, is this really neutral? Is this really fair? And I understand what Dapple Gray is saying here, but there's no such thing as somebody who's going to be completely unbiased and completely without a conflict of interest that is going to get paid for the work that they do in doing an internal company investigation, because the company's hiring them to do it. So that's always going to kind of be on the table, and it's one of those impossible things. The other problem the Lively people have with this on sort of a foundational level is that they say that the investigators are allowing counsel to be in the room. If there's a party or if any person they're interviewing has a lawyer, they have to allow that counsel to be there. And Lively's like, well, that sucks, because that means that Brian Friedman could be sitting in the interviews trying to influence what Wayfair employees have to say. So they don't like that, which I kind of get where they're coming from there. And that's part of the reason why Blake Lively refused to participate in it. And I don't blame her. I wouldn't participate in it either. And I don't think she needs to. The Lively people are also saying, and this is where they sort of push it to another level, because they've been fighting about this since February. They say you are contacting people in your investigation that are also potential witnesses in this case. And there's nothing inherently wrong with that. Anybody can contact any witness anytime they want to, right? But what they're saying is when you contact them, you are misleading and confusing them about what your role is. You're not explaining to them that you're not talking to them as witnesses in the litigation, that you're talking to them as witnesses in the investigation, and that what conversations you have there, they're recording the interviews, could end up being brought up against them in a deposition. It could impact their future testimony, because what if you tell them stuff they didn't know already, and that it could potentially mess up the litigation. Now, the investigators deny all of that. But the Lively folks are like, this is just totally improper because it is happening alongside litigation. And it's interesting because I've had many times where you're in the middle of an internal investigation and then somebody files a lawsuit or somebody goes and files an agency claim. And so you end up running the two. In fact, what you usually do is tell the agency, if it's an investigating agency like the EEOC, you tell them, we're in the middle of an internal investigation. We'll tell you what happens when we're done. So just hold off for a minute. And they usually say, okay. In an active lawsuit in federal court, that's harder to do. But I can't think of a time I've ever seen where the investigation didn't start until the lawsuit was filed. But the issue in this particular motion, this is a motion to compel, and it is a motion to compel all of the records related to this investigation. The witness interviews, the report, the notes of the investigators. They have asked for that stuff from Wayfair, and Wayfair has said no. They have apparently subpoenaed the third-party investigators, and they have said no. And they're both saying no because they're both saying this is attorney-client privilege and work product, because this is something that Wayfair hired these people to do as an employer responding to its responsibilities under California law. And so that is not for public consumption. And I will say that that is usually the case with a private company. It's different if it's a public company. I mean, a public, like a government, like a county or something. But if it's a private company, usually these kinds of things are privileged because that's the reason why you do them, right? An attorney wants to know, do we have liability here? And so you're asking somebody to come in and do an investigation and tell you what the facts are. But the Lively people are saying, but that's different because we're in litigation here and all of this stuff is happening simultaneously, and we can't properly litigate the case without knowing what's going on in your internal investigation. So the way that I see it, for what it's worth, is that this is more of a time issue than it is a substance issue. The Lively people are saying, we want this now. We need this as part of discovery. We need this as we are doing discovery in the case. And my suspicion is that what the Wayfair people are going to say is, if we decide to rely on this in trial, we'll make sure you see it. But right now, you do not need it. It doesn't have anything to do with you. So I don't know if they're ultimately going to have to dig into the is it privilege stuff as much as just can we kick this can down the road. But the Lively people have again used this as an opportunity to talk about how shady and awful they think the Wayfair people are. And they actually sent them a cease and desist on their investigation, and the response to that was super fun to read.